Hello, everyone. Welcome to tonight's program, and thanks so much for being here. I'm Marcia Eli from the Center for Brooklyn History at the Brooklyn Public Library and the library's Arts and Culture team, BPL Presents. Tonight, we have the great honor of hosting two distinguished legal experts, Devon Carbado, the Honorable Harry Pregerson Professor of Law at UCLA School of Law, and co-author of Acting White, Rethinking Race in Post-Racial America, whose new book titled Unreasonable, Black Lives, Police Power, and the Fourth Amendment is the subject of tonight's discussion. And Erwin Chemerinsky, Dean and Jesse H. Chopper Distinguished Professor of Law at the University of California, Berkeley School of Law, whose accomplished career has included serving as the founding dean of the University of California Irvine School of Law, professorships at Duke Law School, University of Southern California Law School, and DePaul Law School, authoring 14 books and over 200 law review articles, and frequent appearances arguing appellate cases, including in the United States Supreme Court. Unreasonable explores how the laws of our land privilege police power over Black lives. Kimberly Crenshaw says, Unreasonable should permanently shift our discussion from bad apples to bad jurisprudence. And Paul Butler describes it as a lifetime achievement of cutting edge work. I'm excited to hear what Professor Carbado and Dean Chemerinsky have to say, but before I hand it over to them, I have a few quick notes for you. First, we have put in the chat a link to the local community bookstore so that you can explore Unreasonable on your own, and if you so desire, purchase a copy from an independent business. Second, you have the option for closed captioning tonight. As always, that button is the bottom of your screen. And finally, I hope you'll share your questions this evening. Type them throughout the program into the Q&A box, also at the bottom of your screen. And with that, it is my enormous honor to welcome our guests tonight. Thank you both for being here. I turn it over to you.
Thank you so much. It's such an honor and pleasure for me to get the chance to Devon. Devon, your book is brilliant. I think we should start by letting you have the chance to tell the audience the thesis of your book.
Thanks so very much. And thanks again for being available in this way. I do appreciate your presence moderating this session and the kindness and generosity that you've shown over the years. So I started to think about this book for three principal reasons. One was to push back against a dominant frame of thinking about race and policing. And that frame is one with which you are all, I'm sure, familiar. And it goes something like this, that problems of race and policing derives from individual police officers engaged in individual acts of violence against individual people. And it seems to me that that understanding obscures the structural dimensions of race and policing, about which I can say more later. So the main reason I wanted to write this book was to say that police violence, racialized policing, isn't a good, bad cop problem. It's a race and structure problem. So I wanted to sort of put that into sharp relief. The second reason I wanted to write the book was to say that problems of policing that we find troubling are not necessarily unconstitutional. There are many forms of policing that we might say are troubling that are constitutionalized, perfectly constitutional, in other words. So the book tries to lay out the different ways in which the law authorizes various forms of police conduct. The third move I wanted to make in the book is to lift up a particular part of constitutional law that I don't think we talk enough about. So here now I'm thinking specifically about the Fourth Amendment. The Fourth Amendment is implicated in just about every form of policing that we might have on our mind. So if we're thinking about arrests, if we're thinking about deadly force, stop and frisk, qualified immunity, warrants, no-knock warrants, driving while black, walking while black, probable cause, reasonable suspicion. We all know something about each of these dimensions of policing, what I fear is that we might not understand the degree to which each of these dimensions of policing are connected to the Fourth Amendment in deep and profound ways. So the story of the book is a story about policing in relationship to the Fourth Amendment so that we can begin to see the problem more structurally, so that we can begin to understand that it is a law problem and not simply a bad cop problem, and that we can then open up space for thinking more capaciously about what we might do about it.
Let me take each of those three in turn. You began by saying that the dominant frame wants to look at the bad cop, the bad apple, but really we need to look at this as a structural problem. Could you elaborate on what those structures are that you see as the problem with regard to policing in the United States?
Sure. So in the introduction of the book, I lay out what I would call a structural framework for understanding race and policing. And I think it's fair to say that when people use the word structure, it sounds a little academic or abstract. Here's what I have in mind when I think about race and policing as a structural problem. There are basically four moving parts that we might consider. Part one is to think hard about the forces, the social forces that stage contact between the police on the one hand and Black people on the other. The insight here is an intuitive one. The more one has contact with the police, the greater the possibility for one to experience police violence. So repeated police interactions create the possibilities for police violence. And we can just pause here for a minute and think about all the structural features of social life that might be at play with respect to, for example, putting African Americans in front of the police. So think about racial segregation. Racial segregation concentrates people in economically depressed neighborhoods where there's always already a perceived need for aggressive law enforcement presence. So we might capture that by way of the war on drugs or the war on crime. These are terms that we use to legitimize mobilizing police officers aggressively in segregated communities. We can also think about police contact on Black people by way of biases, explicit or implicit. To the extent that a group is understood to be quote unquote criminally suspect, that group surely is going to acquire the attention of law enforcement. We can think about the problem of mass criminalization or the criminalization of relatively non-serious activity and how that engenders contact between Black people and the police. So I could go on, but move one is simply a way of understanding that police contact, repeated police contact, creates the possibility for exposure to police violence. Part two is to focus specifically on police culture, police unions, police trainings. And here the question is simply this: to what extent does police culture encourage violence, at least implicitly? To what extent do police trainings ignore problems of violence? To what extent do police unions protect police officers more than they hold them accountable? That cluster of concern is not about good or bad cops, it's about a structure. The third structural feature I think we should focus on is this. So what tends to happen when police violence interacts with the legal system? So we're stipulating that someone's been killed. We're stipulating that someone's been violated. We're stipulating that someone's been abused. There's no dispute about that. What happens when that fact interacts with the legal system? One answer is police violence plus the legal system equals justifiable force. And that can take a number of forms. Maybe it's the prosecutor who says, I'm not going to bring charges here. That's justifiable force. Or maybe the prosecutor brings charges and the grand jury says, I'm not going to issue an indictment. That's justifiable force. Or maybe the prosecutor brings charges, the grand jury issues an indictment, and a trier of fact, a jury or a judge says, reasonable force. These are all moments in which there's no dispute there's been violence, but it interacts with the legal system and it comes out as justifiable force. Another problem with violence in the legal system, you know about, qualified immunity. Don't get me started on qualified immunity. You have to read it in the book, because if I go in the whole of qualified immunity, you'll be saying, come back, Devon, and I won't be able to come back. The basic idea behind qualified immunity, though, which people agree with, left or right, is that it erects a pretty high bar with respect to holding police officers accountable. So qualified immunity is a problem. And the third violence plus the legal system is profound. It's really hard to sue police departments or citizen municipalities for the acts of violence in which police officers engage. Why is all of this important? If police officers understand at the front end that at the back end, A, it's going to be justifiable force, you can't sue the police department, or they benefit from qualified immunity, it means there's no incentive to exercise care with respect to engage people. So these are big structural problems, clusters of problems that are not answered by asking, is this cop good? Is this cop bad? I mean, you just don't get at these more fundamental problems. And Fourth Amendment fits into the picture because it both legitimizes police violence at the back end via its deadly force jurisprudence, but also crucially creates many opportunities for police officers to interact with people at the front end. And it's those front end moments of contact that create the possibilities of violence. I'll say one more thing and then I'll stop. Think about all the examples straight from the headlines where someone is dead in an encounter that started as a traffic stop. We're just focusing on one more moment. Someone is dead in an encounter that started as a pedestrian check. Someone is dead in an encounter that started as a terrorist stop. So we need to think about these front end interactions, what stages them, because they create the possibility for the back end violence that we think is troubling. And this book tries to tell a story about some of those front end interaction dynamics.
You've just done a brilliant job of laying out what you mean by structure. And I want to go back to those in a moment when we get to the question of how do we solve them. But let me, before I do that, go to the second part of what you stated your thesis to be. And that's that much of what the police do is constitutional. It doesn't violate the Fourth Amendment or other parts of the Constitution. I want to give you the chance to talk about that. And I do think it follows from what you were just saying in terms of the initial contacts that police have with people.
So let me give you one example of how that can come into being. And it might be helpful to sort of invoke the precise text of the Fourth Amendment, because again, my sense is that it's a part of the Constitution that doesn't figure in our public consciousness generally, and certainly doesn't figure in our discussions of race and policing more specifically. So if I focus on the text of the Fourth Amendment, so what does the Fourth Amendment protect us from? The Fourth Amendment protects us from unreasonable searches and seizures. That's the core protection. So if we pause and think about that for a minute, it requires for us to identify police conduct as a search or a seizure before the Fourth Amendment is even a game in town. So if the police interact with us in ways that don't amount to a search or a seizure, the Fourth Amendment has absolutely nothing to say about that. Why is that important? Because it means that forms of interaction that the Supreme Court concludes are neither searches or seizures are forms of interaction that don't require any justification. So if I'm walking down the street and an officer approaches me and says, "What's your name? Where are you going? May I see your ID?" The officer has no reason to believe I've done anything wrong. The Supreme Court would say, not a problem under the Fourth Amendment. And I said, but the officer has no reason to think I've done anything wrong. The Supreme Court would say, so what? What that officer has done is not a seizure. So you are technically, quote unquote, free to leave, a legal standard that we can say more about later. So the officer's decision to approach me is no problem vis-a-vis Fourth Amendment law, even if that's racially motivated. Under the Fourth Amendment, it's not a problem because it's not a seizure. One more example from the chapter on traffic stops. Say I'm driving down the streets of Los Angeles and I violate a traffic code in some particular way. Say Erwin's driving down the streets of Los Angeles and he violates a traffic code. Say we both violate precisely the same traffic code. An officer observes us violate these traffic codes. Officer A says to Officer B, look, they're two drivers. They've just violated a traffic code. We can't possibly stop both of them. Let's stop the Black person. And again, just to be clear, racially clear, I would be the Black person, Erwin would not be. So they stopped me. And I want to say that cannot be consistent with Fourth Amendment law. That's unreasonable. Remember, the Fourth Amendment protects us against unreasonable searches and seizures? That's an unreasonable seizure because you stopped me because I'm Black. The Supreme Court, in a unanimous opinion, Ren versus United States, would conclude that that's constitutional. Why is it constitutional? Because I committed a traffic infraction, the notion is. So even though the decision to stop me was race-based, that doesn't violate the Fourth Amendment. That's a unanimous Supreme Court opinion that so holds. So I'm not making a political argument, a normative argument. I'm saying under constitutional law, that is perfectly legal, that stop. That's one easy example of the ways in which race-based policing is constitutional policing.
Let me focus on Ren before I go to the third part of your thesis. You have a whole chapter that's devoted to how to rethink Ren. Ren is important because it says if the police observe a traffic infraction, they're then allowed to pull over the person, even if the traffic infraction was used as a pretext to stop and search the car. Maybe it's worth mentioning Ren involves some undercover police officers in Washington, D.C. They saw a car stopped an unusually long period of time, 15 to 20 seconds. They decided to follow the car until it committed a minor traffic violation, pulled over the car, ordered the driver and the passenger out, did a search for drugs, found the drugs. And the question was, did that violate the Fourth Amendment? And the Supreme Court unanimously, in an opinion by Justice Scalia, as you just said no violation of the Fourth Amendment. A police officer once said to me, if he followed any motorist for 15 minutes, he could see a traffic violation, going a mile over the speed limit, turning without a turn signal, not stopping long enough at the stop sign. So in your book, you have a chapter saying how you would rewrite Ren. Maybe it's worth pausing here and have you describe what you would have done differently in this case.
So one of the striking things about this opinion is, in fact, that it's a unanimous opinion. And Erwin just provided you with an indication of just how vulnerable we all are to being stopped for a traffic infraction. If you look at the code, if you look at the vehicle code and you see the various ways in which we can violate them, it literally means to go in your car and drive is to commit a traffic infraction. I am not exaggerating at all. So that vulnerability means that there is no restraint on an officer's capacity to stop us. And to emphasize another point that Erwin makes before talking about the rewrite chapter, Ren is explicit on the point that I don't have any reason to stop you on the basis of, say, drug possession. I can use the fact that you've committed a traffic infraction as a pretext to conduct that stop. Ren expressly says that that is okay. So it's not just a case in which the court is authorizing racial profiling, as it does. It's also a case in which the court is saying, hey, cops, feel free to use traffic stops as a mechanism for investigating crimes for which you have no reason to believe that someone has done anything wrong. To my way of thinking, this case should easily be decided in to reach a different outcome. Why? Just think about the language of the Fourth Amendment itself. Originalists like to talk about text, that we should adjudicate constitutional cases on the basis of text. The Fourth Amendment has in its text the language of unreasonable seizures. Why isn't it obvious that a case that involves an officer's decision to stop someone on the basis of race is unreasonable? Why is that a controversial argument? We're stipulating that the officer's reason to stop you is race-based. That should simply be an unreasonable seizure. And part of what's hard to understand about that case is that I will typically be in a very difficult position proving that the officer stopped me on the basis of race. You know, how am I going to show that? It's going to be a stupid officer that says, I stopped you, Devon, because you're Black. I'm not even going to be able to prove it anyway. So why deny me the space to even make the argument. So in the opinion that is a rewrite of Ren, the basic argument is this. In thinking about traffic stops, we should think about the quality of the traffic stop and whether a race-based traffic stop changes the nature of it so that we could understand it as unreasonable, consistent with other constitutional provisions. Other constitutional provisions make clear that race-based decision-making is a problem. And we're obsessed with that particular idea in some contexts. And the thinking is, this is just another one in which we should not depart from, but embrace that sensibility.
Why do you think Ren was unanimous? My students have asked me that. Was it that Justices Ginsburg and Stevens didn't see what it was going to lead to? Was it that they didn't care what it was going to lead to?
It's a difficult question to answer. I think part of the answer is that I don't think they fully appreciated what it is they were ultimately authorizing. And indeed, there's some evidence of buyer's remorse in subsequent opinions where they don't quite say, I would have decided it differently, but there is some signaling that maybe we went too far with Ren, or precisely because we did this with Ren, we shouldn't do it over here. So in other cases where the justices are dissenting, they're saying, look what we did with Ren. So we can't now further extend police power because of what we did with Ren. So I think that's part of what is going on. You know, I don't otherwise know how to explain it because it seemed so obvious to me that the opinion is decidedly wrong. And it's a reminder that unanimous opinions don't necessarily mean that they are the right opinions. And this is one example of that. And the final thing I will say might have to do with the sense that, let's say we hold that this is a constitutional violation. Is it really going to change things that much when people won't necessarily be able to prove it? You know, I just cannot figure this one out. It's a puzzle to me.
Let me use that as a transition to the third part of your thesis. I actually want to ask you a similar question to explain a Supreme Court case. The third part of your thesis was really looking at the Fourth Amendment. And maybe I could ask you to talk about a couple of aspects of it. One that you discuss a great deal in the book is the ability of the police to stop and frisk without needing probable cause. And this comes from a Supreme Court case in 1968, Terry versus Ohio. As you point out in the book, the Fourth Amendment says there needs to be probable cause, but Terry versus Ohio says it only has to be reasonable suspicion. You point to the studies that show that this has really opened the door to legitimized racialized policing. So I'd be interested to have you talk about stop and frisk, but then what came to mind as we were talking about Ren, that was an 8-1 decision with Chief Justice Warren writing, the liberal lion William Brennan in the majority, civil rights hero Thurgood Marshall in the majority, and only one dissent.
So you're asking me to account for allies, and I'm having a difficult time doing it. I have a better answer here than I think I do with respect to Ginsburg. So let me get to that. But back up to take us, in fact, to that moment in 1968 when the Supreme Court is deciding Terry versus Ohio. And the issue, to be clear, is to what extent, if at all, are we going to think about stops as seizures and frisks as searches? Remember, as I said at the outset, the Fourth Amendment protects us from unreasonable searches and seizures. So an aggressive move that the government might make in a case like this is to say, look, a stop is not a seizure. A frisk is not a search. So we can stop and frisk people without any justification. They're not implicated by the Fourth Amendment because they're neither searches nor seizures. So if you're an aggressive government, that's the argument you want to make. And some version of that argument was made, not precisely in that way, but let's assume that that's the version that was articulated. Meanwhile, the defendant in the case is saying, I've read the Fourth Amendment, and I'm a textualist, and the Fourth Amendment speaks of probable cause. Now, to be fair, the Fourth Amendment speaks of probable cause with reference to warrants, but that's the standard. And it was understood to be the standard for regulating searches and seizures more generally. So the defendant is saying, look, if you want to frisk me, have probable cause. If you want to stop me, have probable cause. Chief Justice Warren, this is the person who wrote Brown versus Board of Education, departs from the probable cause standard. Says, I'm not going to impose probable cause on this. I'm not going to impose nothing. I'm not going to go with the government's idea that officers should be able to stop and frisk you with nothing. That goes too far in the direction of eroding our privacy, our dignity, and our security. But I'm not going to go in the direction of requiring probable cause, because that stacks the deck too much against law enforcement interests and needs. And so reasonable suspicion, the court doesn't use that language, but that's the language that it became, that came to structure the jurisprudence. Reasonable suspicion is what is required. As law professors, we always, what does reasonable suspicion mean? What percentage is it? And we have fights about this. Law professors fight about the strangest things. What does reasonable suspicion mean? We know that it's lower than probable cause, which you might be asking, what does probable cause mean? That's not a particularly high standard anyway. So Justice Warren's suggestion is that that's what's going to carry the day in this instance, and it needs to carry the day, particularly because we're concerned about officer safety. The line that would ultimately develop in this jurisprudence is we don't want officers to approach people and assume the risk of the gun, assume the risk of the bullet, and so we're going to authorize police officers to frisk people when there's reasonable suspicion to believe that people are armed and dangerous. That's how Justice Warren comes out. Now, the massive footnote to this, and it's a massive footnote, is that the jurisprudence would develop in ways that reasonable suspicion would apply to a zillion instances where there's no concern about officer safety, zero. And Justice Warren could have closed that door better than he did. So reasonable, you can stop someone without a concern about armed and dangerousness. Justice Warren didn't quite say you could do that in Terry, but later cases did. So why do we have Justice Marshall, for example, co-signing that? My surmise about this, and it's just a surmise, and I'd be interested to hear your thoughts. Marshall is new to the court, is a Black man, is on the Supreme Court, first Black person in the Supreme Court. He has a particular progressive identity. His confirmation hearing was contestable, as we all know. There's something about being Black and progressive and contestations around judicial appointments. And so his thinking might have been, I can't in this moment, create a massive fuss about this particular case. Let's see how it goes, A, and B, maybe we will cabinet. Why do I say that? Because the very next Terry case, Adam versus Williams, Marshall is in dissent, saying this is madness. We said we were carving out a very narrow exception, and we don't seem to be doing that. I dissent. And I can't remember when Adams is decided. It might be the very next year, it might be 69. It's soon thereafter where Marshall is very quick to say, I'm gonna stop this madness now. And I regret co-signing Terry to the extent that it's authorizing what happened in Adams versus Williams, which is a case in which someone's in a car parked on the side of the road, 2 or 3 a.m. in the morning, and the officer effectively reaches into the window and immediately frisks the person without really ascertaining whether there was a concern about armed and dangerousness. And Warren and Marshall is asking a question about whether this factual predicate justifies the application of stop and frisk, and to his mind, it did not.
I want to talk about one other aspect of the Fourth Amendment. You alluded to it earlier, and that's excessive police force. If stop and frisk is the initial encounter, as you say, excessive force is what can so often result once there has been that encounter with the police. And the Supreme Court has said, as you point out in the book, that excessive force is litigated under the Fourth Amendment. And you're very critical of the standard for excessive force and how it's applied. I think it's important to discuss that.
I think the basic difficulty with the way excessive force jurisprudence is structured is that the question fundamentally is one of quote unquote reasonableness. So you look at what a police officer did and you ask yourself, A, is it reasonable from the officer's perspective? And the court, in applying that standard, is quite deferential. So the question is not whether the use of force was necessary, it's whether it was quote unquote reasonable. And the court has been very generous to law enforcement with respect to how it understands what reasonableness might mean, in many instances deferring to the officer's claim that, look, I fear for my life. Someone was reaching for their gun. I mean, you've seen all the explanations that travel in the media around these justificatory moves that law enforcement makes. Those don't come from nowhere. They're moves that are part of a broad body of law, effectively where Black people's deaths have precedential life as kind of reasonable mistakes. We don't want to punish police officers for reasonable mistakes. That's a standard line throughout Fourth Amendment jurisprudence, and certainly it figures in the excessive force context as well. So I'd say the fundamental problem there is A, it's about reasonableness and not necessity, and B, there's enormous deference with respect to what it is that police officers articulate as their sets of concerns with respect to the underlying facts, because as the court has said repeatedly, you know, hindsight is 20/20. We don't want to second guess what police officers do. They're working under extraordinary difficult circumstances. And so, you know, deference is in order.
I want to shift from talking about the structural problems that what we just talked about, your thesis, to the structural problems you identified. And I'm really interested here, before we turn to questions from the audience, in your solutions. The first 2/3 of what you said in terms of structural problems are racial segregation, biases, mass incarceration is part of the first, the police culture, biases of the police, training deficiencies to the second. What do we do about those things?
So I will be perfectly transparent in this way and say that, you know, part of the project of this book is to shift the frame with respect to how we talk about the nature of policing, and to be clear about the ways in which the Fourth Amendment is playing a role, expressly authorizing forms of policing that we find troubling. I don't spend a tremendous amount of time thinking about solution. And part of the reason I don't is because as we talk, there are people having robust discussions about different kinds of factors that we should have in mind. Many of those factors don't have anything to do with policing per se. They have to do with racial justice and racial inequality, and the link between those and Black people's vulnerability to policing, and insisting that we think harder about how we imagine the welfare state and its relationship to forms of inequality. That doesn't mean that we should be unconcerned with the governance of policing as a governance structure. You know, the list of things that people have put on the table, we can now all rehearse and we can debate whether we think they matter or whether they end up legitimizing more than they function to dismantle. You know, that's not a matter that we will settle in any meaningful way. So I would simply say that the narrow intervention that I make in the book around reform is, are there changes to law that we should be thinking about? I answer that yes, and I provide some examples, which I won't spoil alert here. B, should we then be thinking about what causes racial segregation, its relationship to schooling and underemployment and unemployment and homelessness and houselessness? Should we be thinking about all of that stuff? Yes. Does that mean that we pull back from the contestations of police governance structures. No, indeed, one could say that, injunctions to police officers probably should be not simply don't violate the law, don't use the power you have to police, to over-police, to kill, quite frankly. There is plenty that the Constitution authorizes you to do that you ought not be doing. So that is a different kind of injunction than bad cop violating the law injunction. So this book invites us to think about the rule of law as a source of engagement, both with respect to our understanding and with respect to the kind of interactions that we might have in public policy arenas around how to take up conversations with the police.
Let me, before I go to the questions, ask about the last part of what you said were the structural problems. And these are much more the problems in the legal system. These are things like qualified immunity. These are things like the standard for excess of force. I would be interested in your talking a little bit, to the extent we're focusing on changes in the law, what would you do?
So there are a couple of changes in the law that I think we can put on the table. So one, if we start with the point that I made about interactions that are not seizures. So remember, I'm not going to give the full itinerary of interactions because then you won't buy the book. But there are a bunch of ways in which officers can interact with us that are predicated on the idea that we are free to leave. So why not put in place what I call you're free to leave at the outset of that interactions? Many of us might still not trust that and think that that particular articulation doesn't mean that we're actually free to leave, but it's better than no warnings at all. That's one move. A second, the free to leave test articulated in its entirety goes something like this. So you are seized if a reasonable person would feel free to leave or otherwise terminate the encounter. Who is this reasonable person? Who is this reasonable person? What is their race? What's their sexual identity? Do we expect that a Black trans person, an undocumented person, a working class white person, do we expect these people to have the same kind of existential relationship to policing? No. So we ought to think about ways of capturing people's identity in answering the question about who the reasonable person is. The Supreme Court is totally, quote unquote, colorblind about this. And I put colorblind in quote because colorblindness is not racial neutrality. Colorblindness is the choice to ignore racial materiality. That's not neutral. That's saying racial inequality is out there. I'm going to ignore it and I'm going to call it colorblindness. So that's important. Qualified immunity, there's lots of discussion around abolishing qualified immunity. And what's striking about that discussion for the purpose of the book, people don't understand that the qualified immunity that they want to abolish and the content of it is expressed through Fourth Amendment law. That understanding isn't there. It's another reason why reading the book and getting an understanding of how qualified immunity intersects with Fourth Amendment law is critical. Abolishing qualified immunity, quite frankly, is not as important as dealing with these front-end matters that I've described. It should be abolished, and my colleague Joanna Schwartz has written quite compellingly about this and has a book coming out that all of you should take a look at as well. So some of these rule of law issues, I think, are relatively straightforward. I mean, your own compelling work in this space, Erwin, I think points in similar kinds of directions about the ways in which we might, in fact, attack the rule of law piece, which is not to say that there aren't other pieces, but we litigate cases. They're real cases. We can't ignore the rule of law pieces. And I think I've taken my cues from you about why it's important not to cede the constitutional domain and think that law doesn't matter, and think that to say that law matters is not to say that it's going to solve the problem, but it is to say that there's a reason why we saw that contestation over the last Supreme Court appointment. That was precisely because who's on the court and how they interpret constitutional doctrine affects the material conditions of life, including Black life. So law is a way to make Black lives matter or not. It's not the only arena, it's not the most important one, but I think that we have to focus on some of the ways in which law participates and legitimizes forms of inequality, including in the context of policing, that we find troubling.
So powerfully said. Let me go to the questions that we've got, and I have lots more questions too that I'd love to ask you, but let me go to the ones that have come in. The first is, what do you see as the impact on mobile phone videos with regard to policing?
So one of the things that mobile phone videos has done quite clearly is to put into sharp relief dimensions of policing that people did not believe were happening. It's not news to many of us that there are these instances of egregious police violence that happen far too frequently, but that don't necessarily acquire the sort of public attention that they deserve. We now have a mechanism to draw public awareness to these instances. And it's not that these moments of revelation are uncomplicated. I mean, how many times do we need to see a particular Black body in pain, or someone literally dead on the ground? I mean, that does something to our sensibilities about people as well. So one worries about the circulation, the mass circulation of images of Black suffering, to be sure. And I have I think it's complicated to sort of understand how that might work with respect to our capacity for empathy and the like. But it's also fair to say that those images have done work to not just engender accountability in the narrow sense, but to facilitate social movement activity in the broader sense.
Let me go to another question as well. Are people of color more likely pulled over and their rights violated because officers think they're less likely than Caucasians to sue and file a police report?
I think there are certainly there's certainly a dynamic about what you might call "quote unquote" bargaining power in the context of policing. And that is to say, to what extent might you become a target because the officer understands your bargaining power to be relatively weak? There are lots of ways in which we can think about that. So it's not just that you're targeting groups because of views about criminality. It's also that you think through what it is you might be able to get away with and accountability. Consider that point with respect to sexual violence and the incident involving Danielle Holtzclaw. So remember that he was an Oklahoma City police officer who engaged in sexual violence against specifically vulnerable Black women. And he really did understand that as a kind of sexual violence quid pro quo moment where he was relying on these women's vulnerability not to speak their truth. He was trading on the historical fact that when Black women speak their truths, they're not heard, they're disbelieved. So do we think that officers exploit those kinds of vulnerabilities? Do we think that that's a part of the policing machinery? Sure, it's a part of the policing machine, and we can always debate to what extent that is so, but that one episode that we don't know enough about still is a reminder of that. It is also a reminder of problems of intersectionality and policing and the ways in which those issues should be on the table. And indeed, this has been a long-standing project of my colleague, Kimberly Crenshaw, who has participated in the Say Her Name campaign and helped to stage that precisely to put into sharp relief the particular vulnerabilities that Black women across identities, Black women understood in its most capacious sense, have continued to experience forms of state violence that are somewhat inarticulable.
Thank you. Let me take another question. I heard you say that in your book, it was changes the laws. Is it the legislative branch, do you think, that is primary jurisdiction for positive change? Will there plausibly be cases that reach the Supreme Court, helpfully challenging the poor decisions we're stuck with now? i.e., is there still a judicial role? Does the court still have jurisdiction for positive change?
Again, I'm going to just try and channel Erwin on this particular point. I think that notwithstanding the configuration of the court, you don't cede that terrain. So that's the first point. And it's helpful to remember that part of what you're doing is creating the possibility for certain kinds of dissents in the hope that we might dissent our way into Supreme Court law at some level. Certainly, people who think from a conservative perspective have done quite a bit of that. The other thing to remember, particularly with respect to policing and the Fourth Amendment, is that the Fourth Amendment provides the constitutional floor. So the Fourth Amendment basically says, look, at a minimum, police officers, we must experience these sets of rights. So police officers cannot violate them at a minimum. States can do better. States can say, I don't think I'm going to authorize a no-knock warrant. I don't think I'm going to authorize stop and frisk with reasonable suspicion. I want probable cause. I don't think reasonableness is enough. I'm going to require necessity. And indeed, California law now requires police officers to legitimize their excessive force use under the rubric of necessity, not reasonableness. So, thinking about other domains of lawmaking and not the Supreme Court is really helpful, particularly when the Supreme Court is more retrenching in its approach to these questions than one would otherwise want.
It's a great point. You talked earlier about, you have a wonderful chapter in the book about Ren that allows the police to do pretextual stops. A number of state Supreme Courts under their state constitutions have rejected Ren and said that pretextual stop is not something that leads to admissible evidence. And it does show that state courts can, under state constitutions, protect more rights than the US Constitution.
And another quick example of that is a ruling by the Massachusetts Supreme Court on what it means to flee the police. So in the context of constitutional law, federal constitutional law, the Supreme Court basically takes the position that unprovoked flight from the police is a basis for suspicion. So a cop is there, I see the cop, I run away, the cop can draw an adverse inference from that. The Massachusetts Supreme Court says that there are rational reasons Black people might want to avoid the police. So you can't take the position a priori that unprovoked flight is per se a basis for suspicion. Again, a state court saying we're not going to co-sign something that the Supreme Court has held.
I also would highlight something you said in passing. It doesn't have to be state courts. It can be state legislatures or city councils or police commissions. You mentioned how California has changed the standard for force when it's deadly force, that it's to be necessary, not just reasonable. Many cities adopted ordinances, in California adopted law prohibiting police use of the chokeholds after the tragic death of George Floyd. So there are multiple avenues for change.
Absolutely.
Oh, please go ahead.
No, I was going to say absolutely. And it's just a reminder that one thinks about this at the institutional level, the city level, the state level, and the federal level, not to mention the social movement activity that creates conditions of possibility for all of these changes in deep and profound ways.
I'll read another question. How might you articulate the relationship between what is read by the court as, quote, reasonable police force and the way that private violence replicates similar types of force against Black people? The Central Park force example, how is reasonableness racially imbued?
So I think that's a terrific question, and it invites us to always pause and think through whether we think there's a hard line between private and state violence, and I don't think there is a hard line. And there are different ways that one can think through why that is so. One is by asking ourselves questions about a phenomenon that we now know is quite real, where people effectively function as private deputies for the police. So they call the police. They call the police to say, this person is over here doing that. When the doing that might be picnicking in their backyard, walking their dog, etc. The police shows up in that particular moment and the state actor is there. So the question about private violence, it seems to me, carries with it the imprimatur of the state in ways that I think we are getting a better handle on, but historically have paid insufficient attention to. It's hard to talk about the history of racial violence in this country and not see the co-constitutive relationship between state and private actors, the most horrific examples of which clearly might be in the form of lynching, public spectacles that were sanctioned and that were made possible by a certain kind of state do-nothingness, or state doing something which is nothing about the fact that these things are occurring. And we can think about other instances of that in the contemporary moment. But the Central Park 5 case, or just going back to the Mr. Cooper, Miss Cooper, also in Central Park, where the threat to call the police was the mobilization of a particular kind of state violence, because Miss Cooper presumably knew again what she was doing, essentially creating a state of emergency. A Black man attacking a white woman in that moment is what an officer would be responding to. So it's a helpful reminder of how we need to be careful in not drawing too stark a line between that which is private and that which is public, particularly with respect to policing Black bodies.
Another question, and it actually relates to the first that we got. How are police video cams contributing to monitoring search and seizure activities?
So this is an ongoing debate that I'm not going to be able to answer in anything like a robust way. I think there was a sense initially that body cams are really productive and they're useful because they engender a sense of accountability. And I think lots of people still feel that way. The counter argument goes to what extent is the control of their usage still a function of individual officers' willingness to turn them on and turn them off? What kind of rules govern when those video recordings are released? So if it's hard to get them to release, what kind of accountability does it engender? And to what extent can those visuals be dissected in ways that really make it hard to tell an overarching narrative of violence? I think we're continuing to have those kinds of debates that I don't think I have a particularly compelling view about.
Let me ask one more question from the Q&A from the audience, and then I want to conclude with a question. The question of the Q&A, Vision Zero, a thesis and approach to traffic violence, holds that manual policing is not integral to safer streets. That studies negatively correlate traffic stops to traffic safety. One proactive measure we society could do is to end or severely limit police interactions with the driving public. Would you support this?
Yeah, I mean, I think that would totally turn, to use the terrible expression, the devil's in the details. I mean, I think I started, you might remember, by suggesting that repeated police interactions create conditions of possibility for violence. So I'm deeply invested in asking very hard questions about the terms upon which the police interact, including by way of traffic infractions. So I think that should be on the table as well. Do I have a firm answer to the architecture about what that could look like? No, but I know that it's off the table in ways that are troubling. So I want to put on the table all the modalities of police interaction precisely because they are potentially violence producing, even as I don't at this point have a clear sense of what the right architecture would be or what the replacement of that might look like.
I want to thank everyone for their terrific questions. Most of all, in our last 5 minutes, I want you to have the chance to express anything that my questions didn't give you the opportunity to talk about. But I thought the way I would pose it to you is, your book has a wonderful title, Unreasonable, Black Lives, Police Power, and the Fourth Amendment. And I'd be interested in why you chose that title and what it tells the listeners and readers about this book.
Thanks for the opportunity to end in this way. It's in some ways, it was a struggle to come to the title. It didn't come easily. And I landed on the title for a number of reasons. One, because it is drawing explicitly from the text of the Fourth Amendment. The text of the Fourth Amendment speaks to the unreasonableness concern and suggests that we should not be subject to unreasonable searches and seizures. That's one piece. The other piece is I want to suggest that the kind of experiences that Black people have with the police is unreasonable, and I wanted to put that into sharp relief. And I also wanted to invite us to think through whether we as Black people are being made to feel unreasonable for raising these particular concerns, because that's sometimes how it feels, that we're supposed to be silenced in the space of forms of state violence that other communities don't experience in the same kind of way. So unreasonable travels in the book in all of those ways, in the hopes that it will open up conversation for a particular understanding of policing that shifts the discourse away from the atomizing concerns about good or bad cops.
I'll simply say to those who are listening, Devon Carbado has written a terrific book. I encourage you to get it and to read it. Whether you know a lot about the Fourth Amendment or not very much, you'll learn so much from this book and be very moved by it. And I think with that, I'll simply say thank you so much, Devon, for giving me the opportunity to be part of this conversation.
No, thank you very much for taking the time. I so appreciate you as an interlocutor, as always. So cheers, thank you. And thank all of you for showing up. I appreciate your presence as well and your questions and engagement.
And I want to thank you both. I feel very fortunate to have been guided by you both through these insights and perceptions. It was very mind expanding, and what a privilege to hear you talk about the book and to hear your wonderful moderation. And I want to let everybody out there know that we've recorded this and it will be posted tomorrow on the Center for Brooklyn History's YouTube page. Please explore the book. We'll put it again into the chat. Our local small business where you can buy it and support small businesses. And I hope that you'll explore our other programs that are coming up. We have 2 more this week and many more coming up down the road. This has been a wonderful conversation, a real mind expanding conversation. Congratulations on this wonderful book. Thank you both so much for your work, and thank all of you for coming tonight. Wishing you all a very nice rest of your night. Good night.
Thanks again.